As I said, it's my pleasure to introduce Kate Chalker, who's a senior solicitor with Cleary Hall Solicitors and works with me in the Sydney office. She's recently had a promotion to senior solicitor, which is obviously a reflection of her hard work and her effort since she's been with us. Kate is in the lucky position of doing predominantly what you'd call our tax and general structuring work, as well as also being involved in the sharp end in doing a lot of the litigation work and dispute resolution work that the Sydney office does. So she is going to talk to us today about estate planning from the perspective of asset protection. So having a look at how we can protect the estate once it's administered, and then also having a look at strategies that we can utilise to protecting the estate against challenge. So I'd like to introduce Kate, and I'll turn my camera and microphone off now and let her fire away.
Thank you, Adrian, and good morning, everyone. Thank you for tuning in this morning for the fifth presentation in this estate planning series. If you have been tuning into the previous webinars, congratulations, you're past the halfway mark now.
Could you try again?
There's my Siri going off, apologies. There will be a further 2 presentations coming up after today, so keep an eye out for any emails regarding those. As Adrian mentioned, I will be turning back to the individual estate planning considerations today and really looking at how those asset protection considerations can overlap and be dealt with in a person's estate plan. So just quickly going through the agenda for this morning's presentation, I'll firstly be discussing why a discretionary trust is often considered the ideal structure in terms of asset protection. I'll look at why it offers the best of both worlds in terms of ownership versus control of assets. And of course, I'll go through the basics and the benefits of using a discretionary trust to hold assets. I will also talk about how a trust can be incorporated into a person's Bloodline Testamentary Trust will, but I'll mainly be focusing on the last 2 dot points there. And they are 2 strategies that we have come up with to protect value in assets, whether those assets are held by an individual or whether they're held in a company or a trust environment. And the final one there is our contractual will process, which really involves a binding legal contract between an individual and a trust to ensure that a person's wishes are carried out upon their death and those assets are protected. Firstly, why is asset protection such a major issue in today's world? And why is it something that clients so heavily focus on when getting their affairs in order? There are a number of different avenues or areas where risk can come from, and different people will have different levels of risk. There is always the risk of a left field claim being made against a person, and that can be regardless of whether they're in business or in an overly risky job. One example there is what I've got as Shanahan's case, and that was an unfortunate situation where a person decided to attend a charity golf day, and while they're out on the field hitting a golf ball, they accidentally managed to hit another person on the golf course with the golf ball, which caused them significant physical damage. And that person commenced proceedings against Shanahan and was awarded $2.6 million in judgment against them. Now, you would think that that person would have been covered under the golf course's insurance policy, but the way that it was drafted at the time, it was only covering members of that golf course. And because Shanahan wasn't a member of the golf club, he was unfortunately not protected from that liability and had a significant judgment handed down against him. So unfortunately, it can just be a matter of being in the wrong place at the wrong time, and a left field claim could be made against any person. Speaking about insurance, many clients will think that they've got sufficient insurance policies taken out and sufficient cover in the event that, for example, an employee were to do the wrong thing or a customer were to be injured on their premises. Now, that may be the case, and it's always advisable to have that insurance in place, but it may be that a particular event or scenario isn't covered by the insurance policy, which could mean that the business or a director of that business could be personally held liable for that damage. So that's always a risk which you need to take account of. The fourth point there about professionals' liabilities, everyone tuned in today would have a higher level of risk than most because we're all professional people giving advice, and that would cover lawyers, accountants, as well as people like doctors, builders, people who are at higher risk of having a claim made against them by a client or a customer. So that's something that we have to recognise when dealing with assets held by those sorts of people. And finally, I've got there about inheritance stories gone wrong and divorce. Now, it may be that a person effectively leaves a will behind and gifts their assets to their children via that will. And that may go on uncontested and those assets be handed down to the children. But there's always that risk there that the children, once they've received that inheritance, that a claim could be made against them, or that they could have a relationship breakdown and that part of that inheritance could be lost to the ex-spouse. So it's not just a matter of protecting the individual will maker, it's also a matter of ensuring that the assets are protected for the beneficiaries of the estate. Because the last thing that you want is to have your hard-earned inheritance going to some other claimant or an ex-partner. As I mentioned, there are different levels of risk depending on whether the person is involved in business or working in a higher risk industry than others. And there's a trade-off in terms of the best structure in which their assets should be held, as well as the necessary insurance policies that they should take out and the roles of control that they may want to hold in their various entities. So as you can see, a business owner there is listed as having higher risk than an individual employee, such as a school teacher or someone like that. And that would lead to considerations of holding assets in a trust for a person of higher risk. Now, there are some tax disadvantages, you might say, that would come with that ownership. And I'll go through those later in this presentation, but that is something to consider. In terms of the control roles, it is possible that a person of higher risk can be appointed to those roles of control, but some people might feel more comfortable being left out completely. It's just something for the client to weigh up in terms of their risk perception. So the simple premise that all asset protection work boils down to is the separation of risk from asset ownership. I've got there, do not have all your eggs in one basket. So that's a matter of determining which person or which entity really has the highest level of risk. So that might be an individual person because of the work that they do, or it could be a trading entity, whether that's a company or a trust. That would obviously be the entity dealing with the public the most and most at risk of having a claim made against it. It may also have debt or finance over its assets. So you would want to separate that entity from the actual safe haven or asset holding entity. That's why often with trading companies, you might see a separate entity there which will hold the business assets, the plant and equipment, the intellectual property, as well as if there's real property which is used to conduct the business. That would often be held in a separate entity and then loaned to the trading entity so that there is that separation of asset ownership from risk. I mentioned earlier that the humble discretionary trust is often considered the ideal structure from an asset protection perspective. And that's having weighed up the three key characteristics of an ideal structure. And those are asset protection, access to CGT concessions, as well as the ability to split income. Asset protection obviously being the main consideration to ensure that if a person or entity were to be sued, that any assets it holds is not lost as a result of that claim. CGT concessions is also important if an entity is expecting to be selling CGT assets. It would obviously be ideal if they could have access to the 50% CGT discount, for example. And then there's also the ability to split income in terms of being able to distribute income amongst various beneficiaries to result in the lowest possible tax outcome. Other considerations which you might want to weigh up in determining which structure is best for you or a client include limited liability and the concept of ownership versus control. By limited liability, I mean that a person's entire asset holding would not be potentially at risk, and they would only be liable to the extent of their investment in a company, for example. That would be the amount paid for the share capital. And really what you want in a structure is you don't want to have the ownership, but you want to be able to exercise control over those assets. And here we've got just a handy little table which explains all of those different considerations in terms of the different asset holding types, being individual, company, discretionary trust, and unit trust. And you can see that for a discretionary trust, we've got the benefit of asset protection. And that's because even though a person might be in all the relevant control roles, they might be the director of the trustee company, they might be the sole shareholder, they could also be in there as principal and beneficiary. Despite all of that, the legal ownership of the trust assets lies with the trustee, which would ordinarily be a trustee company. So in the event that a claim were to be made against the individual, those trust assets would be protected because the legal ownership does not lie with that individual. Another benefit of a discretionary trust is that it does receive the benefit of the CGT 50% discount, which is obviously a very attractive thing for clients. You've got the ability there to split the trust income amongst the various beneficiaries. You've got the benefit of limited liability. And as I mentioned, you've also got the best of both worlds in that you don't have ownership of the assets, but you can exercise control. Now, I'm sure you're all familiar with how a trust works, but just to refresh your memories, there are three essential components of a trust, and they are that you need a trustee, you need trust property, and you also need beneficiaries of that trust. And so the trustee is in that role to manage the day-to-day affairs of the trust and to hold those trust assets for the benefit of the beneficiaries. And they have to act in accordance with their powers and their duties under the trust deed. It's always essential to have some form of trust property, whether that be cash, property, shares, whatever that might be. And that's why you'll find that when we establish a trust, there's a $10 check that comes along with it, because that's really needed to establish that trust. And then obviously the beneficiaries, they're the people or entities who can receive distributions of income or capital or have the trust income applied for their benefit. And that can be a wide range of persons who can receive the benefit of those assets. And so a bloodline testamentary trust will, even though it's called a testamentary trust, it really is a discretionary trust incorporated into a will, which comes into existence on the will maker's death. And that's really ideal because it ensures that the inheritance passes to the beneficiaries in a protected environment. As I mentioned before, the will maker doesn't want their estate going to a child and having that lost immediately to someone suing them or an ex-partner in a family law settlement. If it's passed via a bloodline testamentary trust, the will maker can rest assured that those assets will stay in that protected environment and that the control of those assets will stay within their family. And one of the essential components which we've built into that trust is the distinction between capital and income distributions. We've designed the trust so that the capital of the testamentary trust can only go to the will maker's bloodline. Income, the trustee can decide to give that to the spouses or in-laws of the beneficiaries, but at the end of the day, the capital assets of the trust can only ever be distributed to the bloodline. So that provides a significant level of protection. There's also the supplementary advantage of the taxation of a testamentary trust. And the benefit there is that any minors would be taxed differently to an ordinary trust, in that really they would be assessed as an adult on that income that they receive from the trust. So they can receive the benefit of the tax-free threshold. And so that obviously gives a bit more flexibility and a high advantage in terms of the overall tax position. That's ordinarily not why we would recommend a bloodline testamentary trust will. It is more focused on protecting those assets for the beneficiaries, but it is a handy little advantage in terms of taxation of any income that the trust might receive moving forward. So I've talked about discretionary trust and how it is the ideal structure to hold assets. I'm now going to talk about what we call our secure debt strategy and how a discretionary trust can be used to protect value which people or other entities have built up during their lifetime. And that's really where the exposure is. If a person owns significant assets in their own name and there's a high equity value there which is unencumbered, that's potentially at risk of being lost to a claim, whether that's through business or through a family law breakdown. And now you might think that the most straightforward option would be to transfer any of those significant assets out of the individual's name and into a discretionary trust. Now that certainly can be done, and it would protect those assets once they are in the discretionary trust, but it can be quite unattractive for clients because of the tax costs involved in that. There would be significant capital gains tax payable by the individual or the entity holding the asset, and there would also be stamp duty payable by the trust. So a high transaction cost involved in moving those assets away from the risk person. There's also land tax considerations which would have to be taken into account. If a property is owned by a trust instead of an individual, it would lose the benefit of the land tax threshold. And so that's why we've developed what we call our secure debt process, because it means that the assets can remain in the individual or the entity's name as they are without changing or incurring any additional tax. So what we do with that strategy is, rather than moving the assets themselves, we move away the value attached to those assets to a protected environment. So what we would do there is that we would establish a new trust, a discretionary trust, and the individual can be really in control of that trust and its affairs. And a calculation would be made to work out the equity, the net equity, which is held by that individual via those assets. So if there is a property owned by them, which is valued at $1 million, for example, and they've got a $200,000 mortgage owing to CBA, it's that balance there, the $800,000, which is at risk. So we would work out that amount and we would arrange for the individual to make a gift of that amount to the trust. And now we recognize that the value would really be tied up in the property, and that money wouldn't be sitting in the bank just ready to hand over to the trust. So that's all done by a bearer promissory note, which is a 2-person check, and it's legally enforceable. And once that gift has been made to the trust, it then loans that amount back to the individual. And like any other lender, it would want to take security over that person's assets in the event that the loan couldn't be repaid. And so that security would either be in the form of a mortgage, if it's a real property, or if we've got personal property such as shares, bank accounts, motor vehicles, boats, things like that, the security would be taken in the form of a security deed, and that interest would be registered on the Personal Property Securities Register, or the PPSR. So the effect of all of that is that whilst the person might own their assets in their own name, they've got a debt owing to a discretionary trust, and that trust then becomes a secured creditor of them. So the equity which they hold is really protected for the benefit of that trust. In terms of any existing security, which is already on title, we would need to work with the bank to arrange for them to consent to a second mortgage being registered over the property. It might take some time to get to that stage with the bank's cooperation, but it does eventually get done, and it doesn't affect the secure debt process while we're waiting for that to occur. So if you want to have a look at it from a diagrammatical perspective, we've got the 3 different options there, and this secure debt process can be effective for assets held in any different form, whether that's by an individual, by a company, or by a trust. So you can see there first you've got the gift from the individual to the trust, the loan back of those funds, and then the individual granting security over those assets in favour of the trust. On the right-hand side there, I've set out some of the different issues which can arise upon entering into that transaction, and they really relate to the application of the clawback periods under the Bankruptcy Act. Now, they can be overcome, but it is important to ensure that they're taken into account and that this isn't being done when there's already a claim on foot or something like that, some money that is already outstanding by the person, because in that situation, this strategy wouldn't be effective under the Bankruptcy Act. And we've also got the consideration that a gift or any really undervalued transaction can be clawed back potentially by a trustee in bankruptcy if that is done within 4 years of that person becoming bankrupt. So there is a 4-year clock which we need to start ticking as early as possible. But that date of bankruptcy, it would obviously take a lot to happen before that comes into effect. There would need to be some claim made against a person. They might have some settlement discussions before the dispute eventually proceeds to court. They have to put on their evidence. There has to be a hearing. The court has to hand down its judgment, and then the creditor has to try and enforce that judgment before the person can be declared bankrupt. So 4 years does sound like a long time, but going through that whole process, it is possible to drag that out to make sure that the gift is outside that clawback period. The other strategy which I mentioned earlier really takes that secure debt strategy one step further and works to ensure that a person's wishes upon their death are enforceable and that those assets will not be lost to an estate challenge. We recommend it for clients where they think there is a potential beneficiary who could challenge their will. That might be where they are specifically leaving people out of their will for reasons which they are entitled to, or they may decide to give a higher proportion of their estate to one child, for example, over the others. And so we would recommend this process to ensure that those assets aren't lost to an estate challenge for those reasons. Often clients will ask us, isn't there something you can do to absolutely prevent a challenge being made to my will? And unfortunately, the general answer to that is no, because under the legislation, if you are an eligible person and you have standing to bring a claim, then there's generally nothing you can do to prevent that. But what we try to do through these different strategies is to try and make a challenge unappetizing to that person, in that they're unlikely to have an adjustment in their favour. The only thing that you could potentially do is ensure that assets are not in the client's individual name, because the estate that can be challenged only incorporates those assets which are in their individual name upon their death. Rather, you could have those assets held in an appropriate trust, whether that's a discretionary trust or a Bloodline Testamentary trust. But there are some complications with doing that. Obviously, one of those challenges would be if you move the assets out of your name now before you pass away, there could be some tax payable on those transactions. You've also got potential clawback periods. For example, in New South Wales, we have what's called the notional estate. And unless those assets are gifted to the beneficiaries more than 3 years before their passing, they could potentially be clawed back and could be subject to an estate adjustment upon challenge. So that's one risk. If you want to give your assets away, you need to ensure that you're going to live for at least another 3 years after that happens. And the impediments that clients could face in moving assets out of their name would be that they would lose control of those assets during their lifetime. Obviously, there would be significant tax payable by them on moving those assets to a protected environment. You've also got those land tax considerations in that you might not receive the benefit of the threshold, and that would be an ongoing liability payable by the trust, as well as the fact that it might upset any existing finance arrangements which are in place, and there could be a fair bit of paperwork and administration to do there. So that's why it's important to ensure that you consider asset protection both before a person passes away and after their death. And our contractual will process really achieves both of those things. It's useful for where there are concerns of a will being contested by a disgruntled beneficiary, or where there are unequal gifts to children, and there's a risk that the child who receives less is likely to be upset about that. So I'll just explain to you how the contractual will works. So over there on the left, we've got the asset owner, who is an individual. During his lifetime, he will establish a bloodline trust, and he and the bloodline trust will enter into a will contract. And under that contract, the owner promises to the bloodline trust that he will leave his assets, certain specified assets, to the trust upon his passing. That is then reflected in the person's will, in that he will gift those assets to the bloodline trust. And so once that contract is executed, the bloodline trust has various contractual rights over those assets, which can be enforced once a person passes away to really take possession of those assets. So the main advantage of the contractual will is that it does create those enforceable rights in the trust. It is measurable in monetary terms because we work out the value of those assets, and the trust then receives the benefit of that amount, which can be secured by mortgage or by security deed, like I mentioned with the secure debt strategy. And it does provide priority over other claimants. I'll come to a case a bit later on, but the courts have recognised that any such contracts, like that contractual will, have to take priority over any estate claim. So it would mean that the gift of those assets to the trust would have to be upheld and enforced before any adjustment could be made in an estate challenge. There's future protection by injunction, so the trust could enforce its rights to make sure that no one takes ownership or otherwise deals with those assets. And we've also built in additional protection there so that if an estate challenge were to be made and something were to go wrong, the trust would have the option to acquire those assets under the contract, which would ensure that they remain held in that trust and remain controlled by the bloodline. The benefits of the contractual will process are mainly in terms of asset protection. As I mentioned, it creates priority over the will in that that contract has to be enforced before any estate adjustment can be considered. It creates a liability on the estate, which is very handy because the courts have recognised that it can only deal with a person's net estate. That is, a person's estate once they pay out any debts of the estate. So that amount which would be owing to the trust would have to take priority over any other adjustment. It provides immediate asset protection for the individual in that that security can be taken by the trust during their lifetime. So not only will it ensure that they're protected during their lifetime from risk of business or some other relationship breakdown, but it will also ensure that their wishes are carried out after their passing and that those assets remain within their bloodline. And it gives priority over other creditors during their lifetime as well. In terms of tax, there are no tax implications which arise upon entering into a contractual will. There's no CGT or any stamp duty which is incurred as a result of that. And because the assets are remaining in the individual's name, there's no impact on any existing finance arrangements. So everything really remains the same, but you know that you have that protection in place if a claim were to be made against you during your lifetime, or if you're concerned about your estate administration going to the people who you want. The case that I mentioned before is the 2003 High Court case of Barnes and Barnes. And in that case, the High Court considered a contract a bit similar to the contractual will which we offer. And the High Court in that situation recognised that the liability under the contract, which was established during their lifetime, had to be dealt with and had to be enforced before any gifts could be made under the will. Now, that only applies in the event of a testator family provision application, but it does help in that if an estate challenge was to be commenced, we have authority there in Barnes and Barnes that the contractual will would first have to be recognised and that protection afforded to the trust before any gifts or any adjustments can be made by the court. So just to summarise, in terms of estate planning and protecting those estate assets, the contractual will, the benefits that it offers is that it ensures that assets can pass to the desired beneficiaries without being lost to an estate challenge. And that might be because of a disgruntled beneficiary who has standing to bring a claim under the various estate administration legislation. It also provides protection before a person's passing, whether that be from business or some other relationship breakdown, without incurring any tax implications, whether that be CGT or stamp duty. So that's really why it's the ideal structure which we can put in place for clients who are concerned about risk. So the starting point is to look at a discretionary trust and work out whether that would be suitable to hold a person's assets. But we need to keep in mind any tax costs that might be involved in transferring those assets over to the trust. If that would be a significant problem for the client and the cost would be quite high, then we would consider the secure debt process if they are concerned about risk during their lifetime. And that could be done either in accordance with or separately from the contractual will process. So it's really a matter of sitting down with the client and working out what their areas of risk are and what's keeping them up at night, whether that be a business claim or whether they're worried about their estate assets not going to the people who they want. So we can adapt the various strategies for the different clients and for what their concerns are. That's all I've got for today. If anyone has any questions for me.